and Corrupt Practices Act.
Your Honor, please, to answer the question with the permission of the Honorable Presiding Officer
Proceed.
and with the indulgence of the Honorable Senators, may I be permitted to point out, first of all, that
Why do you have to point out? Answer, yes or no?
the allegations...
I am tired of hearing your voice.
Yes, but the allegations of the complaint determine the jurisdiction of
already
the
seen
court
that, Counsel,
over
in-
the case, Your Honor.
Do not override me. We've already heard that on your pleadings. You've said that in your motion for subpoena. You've said that in your memorandum. Do not be sententious because every hour counts. Kaya, madali lang naman sagutin itong pagtatanong na ito. Ito bang pinapasagot natin o respondent natin ay binibintangan mo sa ilalim ng Anti-Graft and Corrupt Practices Act? Yes or no?
Opo, Madam Senator, dahil nakalagay dito in violation of the Anti-Graft
Absolutely, I
and
can
Corrupt Practices Act.
Give me the presumption of literacy.
Yes.
And don't ever overstep yourself. Ngayon, pagtatanong ko sa iyo ganito, do not engage in a colloquy with me. As I pointed out during the Estrada impeachment trial, you are not supposed to discuss or argue during an impeachment trial,
But
especially when you are speaking to an impeachment judge.
Can we answer the questions,
No.
however, the way we feel
No.
it should be answered?
You should answer according to the rules of court as determined by the Senate acting as an impeachment court. That is the rule here.
Can the specific rule be cited for our guidance, Your
Yes.
Honor? Okay.
The Constitution allows the Senate to promulgate its own rules of procedure. That has been repeated in this instance, and this is the end of this colloquy. How dare you raise questions to my authority? Be careful, because I might request my colleagues to inhibit you and disqualify you from appearing here.
May I intervene, Madam Senator? I would like to explain that the members, the non-elected members of the Senate, as well as the House of Representatives, can argue among themselves, but not to argue against any elected member of Congress, because there is a parliamentary tradition involved in this. Only elected members of the people can use this forum to argue with one another.
I am a senator judge. I'm not here in my capacity as a politician. Politicians, when I appear in a rally, anyone can heckle me, but you cannot heckle me. You cannot engage in what the law calls a colloquy with me. You cannot engage in a discussion or argumentation with me. I'm the judge. I preside here. How many years have you been in trial practice, counsel?
42 years.
And
Your
what
Honor.
have you specialized in? Is it not true that you specialize in maritime law?
In everything, Your Honor.
What an impertinent answer. Let me go to the point, because I might lose my temper with you. Ngayon, sinasabi mo na you are accusing the respondent under the Anti-Graft and Corrupt Practices Act. I have here before me a copy of the Anti-Graft and Corrupt Practices Act. It enumerates what are the acts which establish graft and corruption. Show me or read to me which of this particular listing under the law you are accusing, under which of this listing are you accusing the respondent of graft and corruption? Dahil dito merong A, B, C, D, E hanggang K. I'm talking about Section 3 of the Anti-Graft and Corrupt Practices Act. Number 3, Section 3, Corrupt Practices of Public Officers. O ngayon, turo mo, saan dyan? From letter A to letter K.
Directly, letter C. Can I read?
Yes, please.
Directly or indirectly requesting or receiving any gift, which includes discount.
Will you please stop
Present.
emphasizing your words like this? It startles everybody.
I'll just read softly, Your Honor.
Good, thank you.
Directly or indirectly requesting or receiving any gift, present, or other pecuniary or material benefit for himself or for another from any person for whom the public officer in any manner or capacity has secured or obtained or will secure or obtain any government permit or license in consideration for the help given or to be given without prejudice to Section 13 of this Act. Letter D also, Your Honor, accepting or having any member of his family accept employment in a private enterprise which has pending official business with him during dependency thereof or within 1 year after its termination. And most especially letter E, causing any undue injury to any party, including the government, or giving
Craving something.
To your call for the senator judges, if any, to make an input on this question before you issue your ruling. My first comment is this. Under the complaint, Article 7, the defendant is charged with betraying the public trust, and I'm reading now, quote, through his partiality in granting a TRO in favor of President and Mrs. and her husband, Jose Miguel Arroyo, etc. So the question under Article 7 simply is, did the Chief Justice show any partiality when the temporary restraining order was granted, not by the Chief Justice alone, but by his colleagues in the Supreme Court? That is the question today before us.
Yeah.
Now, I have a copy of the internal rules of the Supreme Court. Rule 12 is entitled Voting Requirements and is self-explanatory, and Rule 13 is entitled Decision-Making Process. It appears, from what the witness has said so far, that she has never personally participated in either counting the votes or in the decision-making process of the Supreme Court. In fact, she has said she has no personal knowledge. She has admitted that. Now, according to the rules of court, Rule 130 on Rules of Admissibility, Section 36, testimony generally confined to personal knowledge, hearsay excluded. A witness can testify only to those facts which he knows of his own personal knowledge, that is, which are derived from his own perception, except as otherwise provided in these rules. If she was absent, how could she have personal knowledge? What? She is in effect, therefore, offering to us her opinion. But I've already said several times in this session hall that no opinion is allowed by the rules of evidence unless the expert has first been qualified as an expert witness. She has not been so qualified. She was not present when these so-called irregularities or discrepancies were taking place. So how can she be a witness on this instance, on the particular point of fact of whether the Chief Justice took an active role in issuing the TRO all by himself, when, according to the witness herself, according to the internal rules of the Supreme Court, which are available to lawyers like us, no one justice is allowed to issue a TRO all by himself. So, defense is correct in invoking the hearsay rule. There are exceptions to the hearsay rule. There are 1 to 11 exceptions. Which of these exceptions is the prosecution trying to ground its position on? The general rule of evidence is no hearsay. Only eyewitness can testify except 1 to 11. Under what exception is being quoted? Why are we splitting hairs? It's very, very clear. A witness can only testify as to what he perceived himself, except that there are 11 of these exceptions, and none of them is being cited by the prosecution panel. So in effect, what we have been hearing is a series of opinions extrapolated or explained to us by the witness. But we have already seen that a witness is not allowed to express an opinion unless she has been qualified as an expert witness. And there are rules for qualifying her. Let me quote only one case, just one case, decided only this month, February 1, 2012, the case of Malayan Insurance Company v. Reyes. Here is the Supreme Court. Concomitantly, a witness may not testify on matters which he or she merely learned from others, either because said witness was told or read or heard those matters. Such testimony is considered hearsay and may not be received as proof of the truth of what the witness has learned. This is known as the hearsay rule. Maybe just one other case, Estrada v. Desierto, 2001. But notice that what I cited was a case issued only this month by the Supreme Court, educating all of us in the law profession and in the general public. Estrada versus Desierto. There are three reasons for excluding hearsay evidence. 1, absence of cross-examination. 2, absence of the manner evidence. And 3, absence of the oath. Now, we are talking, the witness insists that her opinions are well-grounded on the dissenting opinion of a singular justice of the Supreme Court. So we are now faced with the issue of what is the weight of a dissenting opinion. The Supreme Court itself said in the 2008 case concerning Mr. Amado Makasait, quote, the Supreme Court stated that elementary decision-making teaches that we cite the majority opinion as precedent, not lonely dissenting opinions. Another case, 2006, Yes v. Amir-Hazsann. It is the majority opinion and not the dissenting opinion that is the controlling jurisprudence. These are accepted facts in law school. Why do we have to debate these topics? We can safely take them for granted. So to return to Article 7, our quest here is factual in nature. Was the Chief Justice personally and individually responsible for what are perceived deficiencies or irregularities in the issuance of the TRO? The TRO is a subject matter, and the target of this particular Article 7 is the Chief Justice, the respondent. The issue therefore is, can one judge be held liable for the decision of a collegial body? Here is the Supreme Court speaking in an administrative case filed by an individual against certain justices of the Supreme Court, and here is what the Supreme Court said. Although the Chief Justice is primus inter pares, first among equals, he cannot legally decide a case on his own because of the court's nature as a collegial body. Neither can the Chief Justice by himself overturn the decision of the court, whether by division or the en banc, whether by division or by the entire Supreme Court. And here is an excerpt from the book, Judicial Opinion Writing by Joyce George, in its 4th edition, as early as 1993. In writing an opinion, the writing judge is involved in a joint venture. The end product is not his opinion alone, but rather that of all the members of the panel who form the majority. So I return to the issue at hand. The issue at hand is simply like this. Is the witness qualified under the rules of court to testify on this particular matter? Answer no. She said no herself. She said, I'm not a member of the court. I've not been there. I was not present. I was just reading the opinion, the dissenting opinion of one of the dissenting justices. That's what she said. So she's not testifying according to her own personal knowledge. That falls under the hearsay rule. As I said, I admit that there are 11 exceptions to the hearsay rule. Therefore, prosecutor has the burden of showing that at least one of the 11 exceptions to the hearsay rule applies. Otherwise, there's no point belaboring this issue. We can move on. Let's move on, counsel. Thank you, Mr. President.
Thank you.
Mr. President, may I react to the distinguished lady senator and now international jurist?
Proceed.
Mr. President, point of order. He will engage in a colloquy with me, a judge. The judge has spoken. Now the judge is taking time to deliberate on what she has just told the court. I don't think this is proper.
Counsel,
you should debate among yourselves. You do not debate with a judge.
Yeah, counsel, I'm sorry. A member of the court objects.
But also with both counsel. Mr. Witness, what is the provision of the master deed for the columns condominium units with respect to the transfer of ownership?
For that, Your Honor, I don't have an idea.
You don't know when ownership is transferred?
For the ownership, ma'am, I don't have an idea. But for the acceptance of unit, yes, Your Honor.
All right. What is the provision of the master deed on the acceptance of unit?
Once the unit owner accept the unit, Your Honor, that's the only time that we will charge the association dues.
Under the language of the master deed, what is the meaning of accept? Do you have any idea?
Um, that's the time, Your Honor, that the unit owner really accepted the unit.
Think
I mean,
again.
um,
What do you mean by accept? He accepted verbally? He accepted physically? He accepted in writing? What is the meaning of accept?
based on my observation, Your Honor,
Your observation.
yes, Your Honor, that there is a form on there, but that is already for the developer side, Your Honor.
Obviously, you're not very familiar with the legal aspects of the transfer of ownership over the condominium unit.
Yes, Your Honor.
Yes. Now, our issue here is, when should the condominium unit in the columns have been declared in the SALN of the defendant? That is our issue here. To be able to answer that issue, we have to know, when did he become the owner? Now, there are two contending sides and they have different positions. According to the prosecution, the defendant became owner when the certificate of title was issued to him. At that point, apparently, your corporation took the position that the unit was deemed accepted. Is that the language you use?
For the corporation, Your Honor, when I present the master release, it was stated that August 2009, Your Honor, that the unit accepted.
Is deemed accepted when the transfer certificate of title is transferred to the buyer. Is that your practice there in your corporation?
It was accepted, Your Honor. Accepted.
Toto, there are so many methods of acceptance in law. So, what I'm saying is, under your master deed, apparently your corporation has laid down the rule that once the transfer certificate of title has been issued to the owner and accepted by him, then he's deemed to have accepted the condominium unit. You don't need to, that is not a question, but that is apparently the position of your corporation. But on the other hand, the position of the defense is that ownership was not transferred upon acceptance of the transfer certificate of title, but was transferred only when the buyer took full possession. So there are two contradictory views of when ownership was transferred, and therefore also two contradictory views on when the property should have been declared in the SALN. What year? Transfer of title was made in 2004, but apparently declaration was made only in 2009. That is our issue today. Now, I'm going to raise this question with the prosecuting counsel. Counsel, in view of this issue, I will quote to you a decision of the Philippine Supreme Court in Cebu, Winland v. Ong Xiao, which was promulgated in 2009. In effect, in this case, the Supreme Court held that symbolic or presumptive delivery, which seems to have taken place and which seems to be the anchor for the argumentation of the prosecution. Apparently, just to summarize, prosecution takes the position that once transfer certificate of title was accepted by the buyer, that was presumptive or that was symbolic delivery. And since delivery has already been accomplished, then he was the owner as of that date. That is your position. Isn't that so?
Yes, Your Honor, and that
Yes.
is also provided for in the contract to sell, Your Honor,
All
of the
right.
particular unit.
Okay. But in the case of Cebu Winland, which was promulgated in 2009 by the Supreme Court, the court held that symbolic or presumptive delivery by the execution of public instrument, meaning to say the transfer certificate of title, and here I will emphasize what the court said, can be negated by the failure of the vendee to take actual possession of the land sold. What do you say, counsel?
Your
In that
Honor, we have
passage,
cited,
in this case.
we have submitted to the court a memorandum regarding this issue, and we also cited, Your Honor, the case of Marcella versus Court of Appeals.
What case
It
was
was-
that? When was that case promulgated?
It was decided, Your Honor, in March 27 and 2007.
That was 2007. This is
Yes, Your Honor.
2009.
And the facts of the case, Your Honor,
No, excuse me. Let's stay with this particular point. You are citing to the court a 2007 case. The court is citing to you a 2009 case and is asking you to comment on this provision from the Supreme Court case. We are familiar with the rule that the latest case controls.
We have also cited the 2010 decision, Your Honor.
All right. What case was that?
In the case of Raimondo S. De Leon versus Benita T. Ong, Supreme Court said, Your Honor, that under Article 1498 of the Civil Code, the execution of a notarized deed of sale is equivalent to the delivery of the thing sold.
Ah, that is a general rule, isn't
Yes,
that so? So we're just citing a general rule. Here in Winland, Supreme Court is citing a specific rule, and you know the specific prevails over general. Now, you're citing this 2010 case. Let me ask you this question. Did it involve a condominium unit? If you are not sure, you may say so.
I am not sure, Your Honor.
All right. Now, in this Cebu Winland, on which I rely very strongly because it is the latest case, I have to quote extensively from the Supreme Court. I'm quoting now. Article 1497 of the Civil Code contemplates what is known as real or actual delivery when the thing is sold in the control and possession of the vendee. On the other hand, Article 1498 refers to symbolic delivery by the execution of a public instrument. It should be noted, however, that Article 1498 does not say that the execution of the deed provides a conclusive presumption of the delivery of possession. It confines itself to providing that the execution is equivalent to delivery, which means that the presumption can be rebutted by means of clear and convincing evidence. Now, my question to you is, since there is no conclusive presumption, you're only relying on a preliminary presumption that can be overturned by clear and convincing evidence. Isn't that so?
Yes, Your Honor.
Yes, that is your position. I don't think I have... well, let me just ask, for asking sake, the defense counsel. Counsel, what is your position? Did Chief Justice actually accept the unit?
Your Honor, may I draw your attention to paragraph 7.2 of the contract to sell. Specifically, the second half of the paragraph, I will dispense with reading the first part, but the second half which says, if rectifications or adjustments are made in the unit, the seller shall, upon completion of such works, notify the purchaser of the readiness of the unit for final inspection, and the purchaser shall have 15 calendar days from receipt of such notice of final inspection to inspect the unit together with the seller for the purpose of determining whether the necessary rectifications or adjustments requested by the purchaser in connection with the first inspection have been made. In other words, Your Honor, there is a process by which acceptance must be conducted. If there are issues raised, there is a process of consultation and verification in terms of the works being done, in terms of the gripes of the purchaser, before the acceptance is made. Now, we are all familiar with the concept of a deemed acceptance. But when we speak of a deemed acceptance, that is merely a declaration of the seller. It is not perforce a voluntary recognition of the buyer that the unit has been received in good order. That is the issue in this case, Your Honor.
You're raising the argument that the phrase deemed acceptance is unilateral on the part of the condominium seller.
Precisely,
Are you
Your
saying
Honor,
that?
because a deemed acceptance indicates that there has been no acceptance by the buyer.
Counsel for the prosecution?
Your Honor, our answer to that is the applicable rule, Your Honor, is 7.3 of the contract to sell, which came later than 7.2, which is read by esteemed counsel of the defense, Your Honor. And if I may be allowed, Your Honor, 7.3 states, the seller shall be deemed to have delivered the unit and the purchaser shall be deemed to have accepted the unit upon the earlier in any of the following dates, Your Honor. And there are three. The date of final inspection, or if the purchaser fails to inspect the unit within 15 calendar days from receipt of the final notice of inspection. Letter B, the date of possession by the purchaser of the unit. Letter C, the date of execution by the purchaser of the acceptance form. And letter D, and this is where we are relying, Your Honor, is the date of execution of the deed of absolute sale. So when the deed of absolute sale was executed, Your Honor, the prosecution, is of the position that delivery was made. And in the case that I cited, Your Honor, a while ago in Marcella versus Court of Appeals, Supreme Court said that it is of no legal consequence that petitioner did not take actual possession or occupation of the disputed property after the execution of the deed of sale in her favor, because she was already able to perfect and complete her ownership of and title over the subject property. So that is the prosecution's position, Your Honor, that upon execution of the deed of absolute sale, possession was transferred, and according to the Supreme Court, Your Honor, in Marcella versus Court of Appeals, it is of no legal consequence that the petitioner did not take actual possession. And that is our position also in this case, Your Honor.
Your Honor, just very briefly, if I may. I filed a memorandum on February 15th regarding the transfer of ownership, and we cited precisely Cebu Winland, where the Supreme Court held that symbolic delivery by the execution of a public instrument can be negated by the failure of the vendee to take actual possession. Now, good counsel has cited the execution of the absolute deed of sale, and that would have been sometime in 2004. It was, however, at that time, Your Honor, impossible to take actual possession because, as pointed out by Senator Osmeña yesterday, they were just buying space. The condominium did not yet exist, Your Honor. It came into existence in 2006, which is the only point in time, realistically, that any intelligent acceptance of the goods can be made.
Well, gentlemen, you of course realize that the filing of the SAN is governed by the implementing rules and regulations of the Civil Service Commission. Have any of you gentlemen taken the trouble to inquire from the CSC when should ownership be transferred or deemed to have been transferred with respect to a condominium unit?
I'm afraid, Your Honor, that our inquiry into the matter is inconclusive. I am guided, however, by your statements yesterday that we should first have been motivated by honesty. As pointed out by Senator Lacson, the Chief Justice honestly declared this condominium unit in 2010 as testified by Mr. Lim after it was accepted in 2009 by Mrs. Corona. And Mr. Lim further testified that the acceptance was information given to him by the builder or the seller. So we consider that as an admission on the part of the condominium builder or seller that the transfer, the complete transfer of ownership and the free, intelligent, and voluntary acceptance of possession occurred on August 12, 2009, regardless of the provisions on deemed acceptance and the issuance of title in 2004.
Your Honor, for the part of the prosecution, our inquiry with the Civil Service Commission, they informed us, Your Honor, that the SALN form itself, as well as the provision of the Constitution, the Anti-Graft and Corrupt Practices Act, as well as Republic Act 6713, clearly states that whenever an asset, Your Honor, is acquired, it must be stated. And as duly noted by the presiding officer yesterday, Your Honor, when payments were made in 2003 and in 2004 for this particular unit, an asset should have been declared by the respondent, Your Honor, because asset it has an accepted meaning, Your Honor, and no quibbling on the meaning of asset should be debated upon, Your Honor. An asset, when you take out the cash from your pocket, then you get an asset. And this is what we are trying to point out. Acceptance of the unit, Your Honor, is of no moment because in 2003 as well as in 2004, an asset was acquired by the respondent already.
Your Honor, just very briefly, supposing the condominium had never come to be, would that 3-point-something million still be an asset? It would have become a liability.
It is, Your Honor.
If that condominium unit never came to existence and no
Uwian na!
Supervening factor that prevents you from presenting your evidence that you already said to us in January you are going to present. Letter C, it is merely corroborative or cumulative. This does not apply because when you file an impeachment complaint, you have different articles of impeachment which are separate from and independent of each other. So none of these articles of impeachment, just like causes of action in a civil case, are said to be cumulative or corroborative. Cumulative means you already produced evidence in the form of one witness and you just want to add, let's say, 10 more witnesses to completely repeat what that other witness said. That is corroborative. Kaya, kung corroborative lang witness mo, pwedeng hindi mo na ipresenta. Ito naman, hindi corroborative eh. Because they are separate and distinct articles of impeachment. And letter D, the suppression is an exercise of a privilege. Kaya yung defendant, sa bank accounts niya, ayaw niyang magbigay ng consent niya. But we cannot apply this presumption to him because the suppression is the exercise of his privilege. That is a privilege given to any person who opens a dollar bank account. The law provides confidentiality is absolute except only when the depositor is giving his consent. Ngayon ito, kaiba itong inyong kaso na ito. Wala kayong privilege eh. When you file an article of impeachment or a cause of action, it is not only your right to present evidence, it is also your duty. It's not a privilege that you can just waive at will. That is not what the law means by the suppression is the exercise of a privilege. You have no such privilege to bother the court. Cases. People v. Melo Santos, 1995. The prosecution evidence must at all times be competent and admissible to sustain its stand. The prosecution cannot rely on an imaginary person charging a serious offense without extending to the accused the benefit of confronting his accuser. In default of a satisfactory premise for the non-presentation of a crucial witness, it ineluctably follows that disputable presumption that evidence deliberately withheld would be adverse if produced remains undisturbed. May tatago kayo ah. Takot ba kayo? Kayo ang sinasabi nyo? Panalo na kami dito sa tatlo. Kami ang magdesisyon yan, hindi kayo. Ang yayabang nyo. Maaga pa. What are you, conducting trial by publicity? Is that what you're trying to do? We will not be swayed. The entire capacity for tsunami waves by Manila Bay can fall over this impeachment court and will not be affected by what you say in the public or what your chosen public brings back to you, particularly if they've been paid to do so. Please, do not try these little dirty tricks on us. We're all old people here. Tumanda na tayo lahat sa politika, huwag nyo kaming ginaganyan, ha? Kamukha ng survey, just as I predicted. Aba, may balita kanina sa isang dyaryo. Nang survey daw sa UP, 500 ang respondents at like 75% of them said, no, we no longer trust the Chief Justice. Kayo mga UP kayo, dapat kayo i-kick out immediately. If you are true, actual persons, you should be kicked out immediately. Because you do not deserve to be in UP, and the people who machinated the publication of that press release should likewise be kicked out of UP. If they're enrolled in the rolls of the university as alumni, they should be permanently erased from the rolls as a perpetual shame on the university. Pero mo, may survey daw sila na 500 katao sa UP nagsabi ng Chief Justice so far because of the prosecution evidence can no longer be trusted. Ang taas pa naman ang pagtingin ng tao sa UP, pagkatapos 500 lang out of, let us say, 50 million all over the Philippines, and it's not even conducted on scientific basis. It's not conducted by any of those reliable survey firms that have already been proven in their forecast for election results. Kanya-kanya lang sila. Grabe. My goodness me. If I were the symbol of UP standing there, naked, called the oblation, I would immediately throw away my fig leaf. Huwag na tayo magtago-tago pa. Kagaguhan lang naman palang pinapag-aralan sa UP kung ganyan. I cannot imagine a survey where 500 high IQ people will say, we have already lost trust in the Chief Justice because we have already heard the evidence from the prosecution, although we admit that the defense has not yet presented its case. Grabe naman. Sino namang PR firm nag-isip nito? Sabihin lang ninyo, hanapin ko yun. You are playing games. I was not born yesterday. I was born a long time ago and I'm about to die. I want to leave a legacy that at least when presented with this anomaly in trial technique, I rose to condemn it. We will be studied generations from now by other senators faced with other impeachment cases, and I do not want the records to reveal that we allowed this development to pass by uncommented on. This is a travesty. Una sabi nyo, malakas ang ebidensya namin kasi 8 ang krimen niya. 8 ang articles of impeachment namin. Bilangin mo, 8 yan. Pagkatapos ngayon, 2 buwan pa lang, wala na. 3 na lang sa 5. Kasi tama na yun, panalo na kami. Wah! I request the Secretariat should record in our journal that I said, wah!
Silence. Silence.
What is happening?
Anyone can kill you.
The age-old, centuries-old possibly, definition by an English writer called Sedgwick in his book Sedgwick on Damages, and cited in a 1919 case by the Philippine Supreme Court, defining market value as that reasonable sum which property would bring on a fair sale by a person willing but not obliged to sell to a person willing but not obliged to buy. I don't see what would be the utility of discussing what should be fair market value. We should be discussing the question of whether the defendant committed an impeachable offense when he allegedly erroneously misdeclared certain entries or completely omitted certain entries in his psalm. Let us see and I come now to the gist of what I really wanted to say. Let us come now to what the Supreme Court has to say. When you fail to properly and completely file your psalm, what are you committing? What crime are you guilty of? In the most recent case, 2011, Presidential Anti-Graft Commission v. Plato, spelled P-L-E-Y-T-O, PAGC versus Plato, promulgated in 2011, the Supreme Court answered, the failure is not dishonesty but only simple negligence. That prosecution panel should be the topic of your next oral manifestation, and particularly your written manifestation or memorandum at the end of this trial. Here is the Supreme Court speaking, and only as of 2011, Plato's sons are prepared by a family bookkeeper/accountant. Also, his wife has been running their financial affairs, including property acquisitions, which form part and parcel of her lending business. Thus, he was not directly involved, and he failed to keep track of the real property acquisitions. Here is the important sentence. Consequently, petitioner's son was not filed in proper form, containing several inaccurate information. The court had no doubt that the son was inaccurate, but it went on to make distinctions among these 3 terms: gross misconduct, dishonesty, and negligence. It cited the 2 standard laws, remember, that we began with, the Anti-Graft and Corrupt Practices Act, and then the Code of Conduct and Ethical Standards. This is what the Supreme Court said. For gross misconduct to exist, there must be reliable evidence showing that the acts complained of were corrupt, or inspired by an intention to violate the law, or were in persistent disregard of well-known legal rules. That's what you have to prove, prosecution. The Supreme Court went on, and as for dishonesty, it is committed by intentionally making a false statement in any material fact or practicing or attempting to practice any deception or fraud in securing his examination, registration, appointment, or promotion. And then finally, negligence. Negligence, said the Supreme Court, is the omission of the diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. In the case of public officials, there is negligence when there is a breach of duty or failure to perform the obligation, and there is gross negligence when a breach of duty is flagrant and palpable. The Supreme Court goes on. Gross misconduct and dishonesty are serious charges which warrant the removal or dismissal from service of the erring public officer or employee together with the accessory penalties. Hence, a finding that the public official is administratively liable for such charges must be supported by substantial evidence. Prosecution, you have to show at least substantial evidence because this sentence was made in a decision that involved an administrative case, but we are trying an impeachment case. The Supreme Court held that Plato's failure in properly and completely filling out his psalm was not intentional. Supreme Court said, clear from the foregoing legal definitions of gross misconduct and dishonesty is that intention is an important element in both. Missing the essential element of intent to commit a wrong, this court cannot declare petitioner guilty of gross misconduct and dishonesty. An act done in good faith, which constitutes only an error of judgment and for no ulterior motives and or purposes, does not qualify as gross misconduct and is merely simple negligence. And so in the Plato case, the Supreme Court said, thus, at most, petitioner is only guilty of negligence. You have your work cut out for you. Prosecution panel, show that an omission or a misdeclaration was deliberately intended by the defendant. You must show essential element of intent to commit the wrong. Now, in another case, the court found that the defendant was guilty and should be removed from service. The Office of the Ombudsman v. Racho, also a 2011 case. So we have two cases to choose from because the latest case always controls the jurisprudence. In this other case, Ombudsman v. Racho, the court found Racho guilty of dishonesty for non-disclosure of his bank deposits in Saln. Here is a note of caution to the defense. Defense panel, has your client, the defendant, disclosed in his Saln all his bank deposits, peso and dollar deposits? Because if he did not, but he admits that he made those deposits, then under the ruling in Ombudsman, under the ratio decidendi, then your client is guilty. In this particular case, the Supreme Court defined dishonesty. It said, dishonesty begins when an individual intentionally makes a false statement in any material fact or practicing or attempting to practice any deception or fraud. And then finally, just for emphasis, one more case that challenges the position of the defendant. Carabeo v. Court of Appeals in 2009. He was officer in charge of the treasurer of Parañaque City. He accumulated several properties and was able to travel abroad 15 times. He did not disclose this in his Saln. He alleged as a defense that he can simply correct the entries made in his Saln. But the Supreme Court said that while the law indeed allows for corrective measures, the defendant was charged not only with violation of the Anti-Graft Act, but also violation of the Penal Code. He failed to show any requirement that prior notice of the non-completion of the Saln and its correction precede the filing of charges for violation of its provisions. I will now stop myself. I will challenge these two panels. Number one, prosecution, show that there is intent to commit dishonesty on the part of the defendant and you've won your case. On the part of the defense, show that your client has, in good faith, declared in his hand all his deposits, both peso and dollar deposits, and if he did not, why not? Please take these cases, decided cases that I've cited accordingly. Thank you.
Hilo is recognized.
Thank you, Mr. President. It appears to me that we have come to the point in this impeachment trial when we are faced with the centerpiece of the prosecution, meaning to say the accusation against the filing of the SALN, Statement of Assets, Liabilities, and Net Worth by the Chief Justice. It appears to be the showpiece of the prosecution, and therefore we must take time, not only take time out of number crunching, which you were doing last week, and see what the Constitution and what the Supreme Court have said about the filing of the SALN. First, let me begin with Article 2 of the Articles of Impeachment. I will read it verbatim. Respondent committed culpable violation of the Constitution and or betrayed the public trust when he failed to disclose, I repeat, when he failed to disclose to the public his statement of assets, liabilities, and net worth as required under Section 17, Article 11 of the 1987 Constitution. Notice that this heading under the Articles of Impeachment only uses the phrase failed to disclose. If we had disclosed and we are going to apply this article literally and very strictly, then there is no more case, because it turns out now that he disclosed his statement of assets and liabilities as provided by law, as I shall explain later. So in my view, Article 2 is suffering from at least incompetence in phraseology, because if we were to apply it strictly, if there is evidence, and evidence has been shown in this court, that defendant failed to disclose, meaning to say, failed to show his statement or make his statement of assets, liabilities, and net worth unavailable or inaccessible to the public, then he would have committed the impeachable offense. But if he already took steps to do otherwise, then the whole case falls. What I'm saying is that Article 2 should have said when he failed to disclose and he failed to declare, because declare and disclose are two separate things. As we shall see when we look at the Constitution, Article 11, Section 17, a public officer or employee shall, upon assumption of office, and as often thereafter as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. Notice, therefore, that the first requirement by the Constitution is to file a declaration. You declare what your assets and liabilities are. And then, in the closing sentence, the Constitution says, the declaration shall be disclosed to the public in the manner provided by law. This is the second requirement, the requirement that it should be disclosed. There are therefore two requirements. First, that he declared. Second, that he disclosed. It appears now that the Chief Justice both declared and disclosed, so the case is closed. But in the spirit of liberality, we have taken note of the explanation of the prosecution of its Article 2 on the Articles of Impeachment. Now, let us look at what our Supreme Court has ruled concerning the filing of the SALN under this constitutional provision. In the 203 case of Francisco versus Nagmamalasakit, etc., Supreme Court said, a determination of what constitutes an impeachable offense is a purely political question. We cannot settle it by citation of authorities or by citation of cases. It is a purely political question, said the Supreme Court. The Constitution enumerates 6 grounds for impeachment. 2 of these, namely other high crimes and betrayal of public trust, elude a precise definition. But the issue calls upon the court to decide a non-justiciable political question, which is beyond the scope of its judicial power. Therefore, we are making history with this particular impeachment case. We are deciding a political question. What are the failures or the omissions in the filing of the SALN that would constitute an impeachable offense? Notice that in the United States Constitution, it is impeachable. It is possible to impeach a high public official for crimes, quote, and for misdemeanors. We did not use the phrase and for misdemeanors because misdemeanors in common law systems are mere faults or failures to observe minor ordinances. So our Constitution contemplates a very high crime. We have to see then what is the meaning of a high crime. In the records of the Constitutional Convention, we find at least this sentence. For graft and corruption and betrayal of public trust to be ground for impeachment, their concrete manner of commission must be of the same severity as treason and bribery, offenses that strike at the very heart of the life of the nation. They kept on repeating this clause in the Constitutional Commission, offenses that strike at the very heart of the life of the nation. That is, in pari materia, with all those other obviously high crimes that are enumerated in our Constitution. Our question, therefore, is not about how do you distinguish this value from that value, assessed value, acquisition cost, fair market value. We're not number crunchers. This is a quasi-judicial and quasi-political proceeding. This is not a quasi-accounting proceeding. So the question is whether there is any discrepancy or omission in the son of the defendant Chief Justice that strikes at the very heart of the life of the nation. Now I come to a famous, or according to your view, an infamous statement that was made by an American president during the attempt to impeach one of the most famous justices of the U.S. Supreme Court, Justice William Douglas, in April 1970. At that time, Gerald Ford, ultimately president of the U.S., was just a representative, and he maintained this infamous statement. An impeachable offense is whatever a majority of the House, or in our case, 1/3 of the House, considers it to be at a given moment in history. So we are actually writing the book for what is an impeachable offense. Conviction results from whatever offense or offenses 2/3 of the other body, meaning to say 2/3 of the Senate, just like the Philippine Senate, considers to sufficiently serious to require removal of the accused from office. So it is for us to decide what is impeachable in terms of the Psalm. Now, I have already made a passing mention of the Constitution. Let us go to the laws that are meant to implement the constitutional provision. The first law is called the Anti-Graft and Corrupt Practices Act, RA number 3019, Section 7, Statement of Assets and Liabilities. Every public officer within the month of January every other year shall file statement of assets and liabilities in the proper case with the office of the President, or in the proper case with the office of the Secretary of the corresponding House or the corresponding chamber. Next law, Code of Conduct and Ethical Standards, RA number 6713. The provision of the first law that we cited, Anti-Graft and Corrupt Practices, was expanded by the Code of Conduct. And it said, the two documents, meaning to say the statement of assets, liabilities, and net worth, and the statement of financial disclosure. It says, and I'm quoting, these two documents shall contain information on the following. Letter A, real property, its improvements, acquisition costs, assessed value, and current fair market value. That's all that the law said. It did not indicate how we arrive at these values. It just says that the Psalm should contain information on real property, its improvements, acquisition cost, assessed value, and current fair market value. Who determines this? The proper public officials. So there is no need for this impeachment court to argue lengthily on what is acquisition, what is assessed, what is current fair market value. These are determinations made by the proper legal officer. And further, the Code of Conduct provides the Psalm shall be filed by, in the case of senators and congressmen, with secretaries of the Senate and the House respectively. In the case of justices, with the clerk of court of the Supreme Court. We have already heard evidence that the Chief Justice filed his declaration, and he filed it with the correct official, the clerk of court, from whom the public may see fit, by the proper procedures, to get a copy. Not only do we have these two laws to guide us, we have to look at its implementing rules and regulations, particularly of the Code of Conduct. The Code of Conduct, implementing rules and regulations, reflects the law itself, meaning to say the Code of Conduct, in providing that the statement of assets, liabilities, and net worth shall contain information on the following. And it repeats: real property, its improvements, acquisition cost, assessed value, and current fair market value. In the implementing rules and regulations, we find the following statement: in the event said authority determines that a statement is not properly filed, they shall inform the reporting individual and direct him to take the necessary corrective action. The individual to whom an opinion is rendered, and any other individual involved in a similar factual situation, and who, after issuance of the opinion, acts in good faith, underline, acts in good faith, in accordance with it, shall not be subject to any sanction provided in the Code. Underline, shall not be subject to any sanction in the Code. This is the basis for the theory by some that since any failure or omission in the SAL has now been decriminalized, it should no longer be considered an impeachable offense because of this provision in the implementing rules and regulations of the Code of Conduct. And there are certain provisions that are provided for failure to do so. Now, we have looked at the two laws. We have first looked at the constitutional provision. We have looked at the provisions of the two major laws, the Anti-Graft and Corrupt Practices Act and the Code of Conduct and Ethical Standards. Now let us look at the even lower level of legislation, the civil service rules. You all know by now that the recent guidelines issued by the Civil Service Commission are supposed to govern declarations made for 2011 and thereafter. And there are definitions of terms in this guideline. But among the most salient provisions of the guideline is, for computation purposes of real properties, acquisition cost shall be used. That's what the law says. You use acquisition cost. In the past, people did not know what to put in their SALs, and the law did not say anything. Then eventually the law said you can put either acquisition cost, assessed value, or fair market value. Civil Service Commission in practice ruled, although the conjunctive is used for these three values, the conjunctive of and, actually it should be interpreted as or. So you could just choose any of the three. But now we have in this new guideline by the Civil Service Commission that when we compute our real properties, we should use acquisition cost. There's no more question about this. If the public officer fails to comply with the law, he can be charged under the penal code with the crime of falsification for untruthful statements or for perjury. So we have taken a look now by this time at the Constitution, the applicable laws that are meant to enforce the Constitution. But let me go more deeply into the matter of the failure to disclose or the failure to declare or the omission of any declaration. The Civil Service Commission issued the recent guidelines that will govern 2012 and onwards. And it declares that for computation purposes of real properties, acquisition costs shall be used. So you and I, as members of Congress, of the House of Representatives and of the Senate, beginning from 2012, should now use acquisition costs for our SAL. But before this guideline by the Civil Service Commission, our bureaucracy was governed by the older guideline issued by the Civil Service Commission in 2006. 2006 resolution of the Civil Service Commission does not provide any guideline. The SAL filed by Chief Justice in 2011, but covering the period of 2010, as well as all his previous SALs, was filed according to the old resolution of the Civil Service Commission. I have already said, and I repeat, According to Civil Service Commission, at that time, under the old guidelines, which was very deficient, or let us just say non-specific, it is not necessary to fill up all three values. You could just choose among fair market value, assessed value, and acquisition cost. Now let's come to the question, how should the current fair market value be computed? We have already been told that there are provisions in the local government code because the municipalities formulate a schedule of fair market values, and this is what is applied by the city assessors. In our present case, the defendant based the
Taste the tropical vibe.
It is the mind of this presiding officer to request both parties to submit the respective memorandum on this specific issue, not only for the information of the public, but for the guidance of this court as well. And this presiding officer will make a statement after everybody has spoken.
If Your Honor,
Mr.
please.
President.
Very willingly, we will comply, Your
May
Honor.
I just let the defense counsel first to finish?
Very willingly, Your Honor, we will comply. But may we request that we be given at least 5 days, Your Honor, in view of the importance of the issue involved, Your Honor.
Granted,
Thank you, Your Honor.
granted,
May we ask for the same period as well, Mr. President?
granted.
Mr.
Thank
President.
you, sir. The gentleman from Pampanga.
Yes, on the issue of the memorandum, if you may also consider explaining to this court why you would consider subpoena or a subpoena of this court in the same category as a warrant of arrest or a search warrant. Please.
Yeah,
so that we may-
definitely we will.
Thank you.
Definitely we will.
Yes, sir. Mr. President, may we recognize Miriam Defensor Santiago on another issue.
This is a legal manifestation addressed to both panels. Gentlemen,
The
you may
gentle lady from Iloilo is recognized.
Thank you. Gentlemen, you may
Tignan
take
mo nga
your
dito
seats.
yung-
In the first place, I don't understand why we are discussing a search warrant. This court has not issued a search warrant. What search warrant are we talking about? What we issued was a subpoena. Therefore, the issue should be, what are the effects of the subpoena, considering that when the subpoena was requested for by prosecution, it attached what purported to be bank documents. But immediately, the prosecution disavowed any knowledge of the authenticity of the document. Therefore, the issue is, can counsel in any proceeding attach to his request for subpoena a document about which he knows nothing? That's the issue. Hindi mo pala alam kung ano yun eh. Bakit mo sisingilin kami na issue kami ng subpoena? Eh ano yun? That's only a scrap of paper. Why are you doing this to the court? Why didn't you go hit your law books? So, kung ano-ano mga pinagsasabi nyo ah. Hindi naman ito kursunada eh. Siguro ito sa jurisprudence. Dito sa inyong supplemental request for subpoena / reply dated February 3, paragraph 11. I will start even earlier. Paragraph 10. Recently, an anonymous source provided the prosecution with photocopies of what appears to be PS Bank documents without more. Pwede na ba yun sa korte? An anonymous source told us. So we're alleging it in our request for subpoena. Is that allowed? Can you allege something in open court or even in a written pleading with a court that you have information, but it's based on an anonymous source? My goodness, if you bring this to any trial judge in the entire country, particularly in Metro Manila, you'll be cited for contempt. I know that I said that impeachment is quasi-judicial and quasi-political, but you cannot tamper with the rules of court which are suppletorily applicable to our rules of the Senate on impeachment. Saan ka nakakita ng pleading na somebody anonymous said like this to us, so we're going to ask the court to do something. What kind of respect for the Supreme Court are you entertaining in your minds? Pangalawa, basahin ko sa inyo, this is a very, very strange, bizarre document. Imagine telling me if I were a trial judge, an anonymous source told me, Your Honor, that something happened, so will you please issue a subpoena? Can that be a basis for issuance of subpoena? Paragraph 11. Moreover, it seems that the media itself also has information. Kailan naman ng judge pwede mong hikayatin o pwede mo pakiusapan na gumawa ng kung anong mga aksyon na gusto mo, issuance of a subpoena, on the basis of a media account? My goodness! Is this government by media or is this judicial system by media? Again, this is a ground for contempt. If I were a trial judge, I would say, you're wasting my time. Sheriff, take him to city jail. Direct contempt yun eh. Pero mo, if you're going to the court in a serious frame of mind, you're met by this kind of a pleading. May narinig kami sa isang babae na hindi namin masabi kung sino yon. May nabasa kami sa dyaryo. Opposing counsel in all trial courts of our country will go apoplectic objecting to that kind of a request. May just point that out to those people who have never been to trial court. Paragraph 12. While it cannot vouch for the authenticity of the said documents, the prosecution believed that it is its duty to submit the documents to this court as they may have a bearing on the court's resolution of the pending request for subpoena. Huh? Say again? One, I heard someone who I cannot identify say something. Number two, I read it in the media. Now, it is my duty to bring it to the attention of the court. Duty my foot. It is not your duty. It is your liability. That is disgrace to the judicial system. And I have basis for saying that.
Yes.
I will read you the case. In these cases of false or fake documents, which yesterday the bank manager asseverated, she said, that's a fake document. In the case of fake documents introduced in court, here is what the Supreme Court had to say. Based on administrative cases against certain judges, an administrative case is a case for disbarment. Ganon katindi. Pag nagbigay ka ng peke dokumento, peke na testimonya sa korte, ganon katindi yan. Pwede yung base, ipa-disbar mong abogado. There are two cases. One, where the lawyer himself did not know that the document was false, did not participate in its preparation. And the other is where the lawyer willfully introduced what he knew to be fake documents. Let's talk about the first instance. The lawyer willfully knew the document was fake. Here is what the Supreme Court said in Samala v. Valencia. I beg the indulgence of this court. I'm hyperventilating because I'm very, very upset. I will leave this court immediately because I'm sure I have hypertension. Samala v. Valencia, 512 Skra, 1, decided in 2007. Here is what the Supreme Court said. Respondent cannot feign ignorance of the fact that the title he submitted was already canceled. In other words, the Supreme Court is saying, we are concerned, we are aghast that the lawyer knew that the document he submitted was false. Respondent failed to comply with Canon 10 of the Code of Professional Responsibility, which provides that a lawyer shall not do any falsehood, nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. It matters not that the trial court was not misled by respondent's submission. Notice the court said, even if that false document did not mislead the court, still the lawyer is liable. Because the burden should not be placed on the court to determine whether the document is true or not. It is the duty of the lawyer who is introducing it. It matters not that the trial court was not misled by respondent's submission. What is decisive in this case is respondent's intent in trying to mislead the court by presenting this document. That's what the Supreme Court said. If the lawyer willfully introduced fake document, the Supreme Court will condemn the lawyer. I will see what the penalty was. Accordingly, the court finds the lawyer guilty of misconduct and violation of canons 21, 10, and 1 of the Code of Professional Responsibility. He is suspended from the practice of law for 3 years, effective immediately upon receipt of this resolution. That is a decided case. It binds us all here. But that is in the case of a lawyer who knowingly and willfully introduced a fake document. Now let us grant the presumption of innocence to the prosecution panel. Suppose they did not know, as they indeed said in their pleading, they could not vouch for the authenticity of the document. Do they still have any liability? Yes, said no other than former Chief Justice Enrique Fernando, one of the most brilliant lawyers produced by this country. Justice Fernando wrote, in the case of Berenguer v. Carranza, 26 CRA, CRA 673, promulgated in 1969. The lawyer had, in the preparation of the fake document, the lawyer had nothing to do with it. And therefore, the charge of deliberate deception obviously cannot be sustained. But, the court went on, would that of itself entirely exculpate him from any responsibility? The answer must be in the negative. Maski hindi mo sinadya, maski hindi mo naintindihan na peke pala yon, pag na-introduce mo yan evidence at natuklasan na peke pala, ay may pananugutan ka pa rin pala. As was correctly pointed out in the complaint, his failure to exercise greater care did result in the confusion and prolongation of the suit. Kasi nalilito kami eh. Under the circumstances, it would be to err on the side of undue leniency if he would be held blameless. He had incurred liability. His fidelity to his oath as attorney was less than entire. Every member of the bar must be on his guard, lest through oversight or inadvertence, the way he conducts his case or the evidence he presents could conceivably result in a failure of justice. Even if there be no intent to deceive, therefore, a lawyer whose conduct, as in this case, betrays inattention or carelessness should not be allowed to free himself from a charge thereafter instituted against him by the mere plea that his conduct was not willful and that he has not consented to the doing of the falsity. The Supreme Court found him guilty and issued a penalty of reprimand with a warning that repetition of the offense will be more severely left with. This is the ruling of the Supreme Court. Pinalitan na ba natin itong mga ruling na ito? Pwede na pala ngayon, maski media ka, pwede mo nang i-narrate sa korte na hindi mo naintindihan kung tama yun o totoo yun o binigay yan ng PR, ng Dirty Tricks Department na kung sinong PR firm. Come on! Wake up! We all know how politics is done in this country. Just because you admit that this is a quasi-political proceeding does not mean that you can turn this into a completely political circus. Kaya, I submit to my colleagues, I respectfully submit to these colleagues, my colleagues, what is the role of media while this trial is pending, while this trial is sub judice? Pababayaan na lang na ba sila na magbibigay ng kung anong lead dyan na identify tayo isa-isa. Itong mga senador na ito, pro-Aquino ito. Ito naman, pro-Corona. What does that say of our integrity? Pabayaan lang ba sila? Libreng-libre ba sila in the name of freedom of the press? I think we should think very carefully about the sub judice ruling. While a case is pending in court, there is a gag rule. No person may orally or through other means, by media, for example, comment on the merits of the case. Even we are not allowed to do that. Shall we allow media to do that? Nilista tayo isa-isa, dito kaliwa, dito sa kanan. May kaso dito ah. Ay di kung ganun pala, if this is going to be trial by publicity, let us invoke the Constitution and ask for a change of venue. Perhaps out of the country. We all know that the Constitution itself recognizes that public opinion can be so prejudicial in a pending trial that under the Constitution, the Supreme Court may order a change of venue. Ganon katindi ang ayaw ng korte ng is public opinion that will teach lawyers who have trained for 9 years to become lawyers on what the law is or how it should be applied by people who have never applied the law in trial court. Kung ganito ito, huwag na tayo magbasa pa. That is all, Your Honor. Thank you.
Thank you. Now, may I now state the position of this humble presiding officer and this...
Hahabulin ba talaga?
Please do not be nervous. I am very
So cold.
practiced with witnesses who come to court for the very first time. I strongly suggest that you take a sip of water, which is what we do when the witness is disturbed. And please do not think that I'm going to try and trap you with a clever question. I will not do that with you, since you are in effect an impartial witness. I want to reveal you to the public in all your beauty and in the full glory of your college education. I am your friend. It appears from your narration recently that you were deeply disturbed by the visit of Mr. Banal. Is that a correct impression?
Yes,
You
Your
were
Honor.
so disturbed that you went on a round of talks from one superior officer of the bank to another. Isn't that so?
Yes, Your Honor.
And you had reason to be, because I think even only subconsciously, you remembered that you and he were talking about a foreign currency deposit. You are talking about a foreign currency deposit that did not belong to him. Is that why you were disturbed?
I was disturbed, Your Honor, because apparently this person was holding what seemed like a bank document which was supposed to be
Absolutely
confidential.
Yes. So you're putting it in another way, but more or less we have reached the same conclusion. And maybe even only in your subconscious you remembered, maybe during your seminar or orientation as a bank manager, that under the law called Instituting a Foreign Currency Deposit System in the Philippines, Section 8, which is entitled Secrecy of Foreign Currency Deposits, provides that all foreign currency deposits, etc., are hereby declared as and considered of an absolutely confidential nature, and except upon the written permission of the depositor, in no instance shall foreign currency deposits be examined, inquired, or looked into by any person. I think that, as a college graduate, it was impressed in your mind that even if a person merely asks a question about a foreign currency deposit that does not belong to him, he's already violating the law. Would you say that?
Yes, Your Honor.
Yes. Because the law is very, very strict. It says, Section 8, Secrecy of Foreign Currency Deposits. These deposits are of an absolutely confidential in nature and, except upon the written permission of the depositor, in no instance, that's the law speaking, in no instance shall foreign currency deposits be examined, inquired into. Inquired into. The law even prohibits any person from asking any question. Inquired into or looked into by any person, government official, bureau of office, etc. So the prohibition is absolute. Even any ordinary person, without showing any motive or fraudulent intention, the minute he walks into a bank and asks about a foreign currency deposit from the branch manager's head should already resound with bells and whistles because the law prohibits you not only from giving information, but even the person or the visitor from asking about it. I think that was the reason for your unease after the departure of your guest. And you were correct because under Section 10 penal provisions, any willful violation of this act or any regulation by the Monetary Board shall subject the offender upon conviction to imprisonment of not less than 1 year nor more than 5 years or a fine. So I have raised this question with you just to assure you, since you look so miserable there on the witness stand, that what you are doing was completely correct. You are acting pursuant exactly to the language of the law, unlike a lawmaker who, although a lawmaker, was already a lawbreaker. I do not wish for you to answer this question. That is my personal view as a lawyer and as a judge here in this court. Perhaps people should read the law more carefully, particularly when they're entrusted with making the law. And may I say there is a similar provision with the domestic currency deposit law. Now, I'm no longer going to ask you a question. I will just make a manifestation. I'm no longer talking to you. I would like to manifest to my honorable and distinguished colleagues in the impeachment court. According to the timeline I have tried to draw, Mr. Banal received a copy, an anonymous copy of the signature card on January 30. He has no clue where it came from. On February 2, Representative Reynaldo Umali received an envelope purporting to contain also the same documents with signature cards, and he has no clue where it came from. What is a judge to make of this situation? The judge will, of course, turn to the rules of evidence, particularly Rule 131, Section 3, entitled Disputable Presumptions. The following presumptions are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. A, B, C, etc. Letter J, that a person found in possession of a thing taken during the doing of a recent wrongful act is the taker and doer of the whole act. Let me repeat. Disputable presumption that a person found in possession of a thing taken in the doing of a recent wrongful act is the taker and the doer of the whole act. If a person is found in possession of signature cards relating to a foreign currency deposit, which the law declares to be absolutely confidential except for the written consent of the depositor, if he is found to have it in his possession, he cannot say without more, for to allege is not to prove. He cannot say without more evidence that he does not know how it came to his possession, because then the law steps in and raises the disputable presumption that he was the thief of that signature card. That is the presumption in our rules of court. Of course, it can be overcome by substantial evidence, depending on the judgment of this court. Let me also go on, since I'm citing the disputable presumptions. Letter Y, another disputable presumption that things have happened according to the ordinary course of nature and the ordinary habits of life. Again, that is a disputable presumption. Normally, short ladies, short, long, tall, white, broad, etc., do not give us incidents unless documents, unless we know her, or if she is anonymous, then we stop her. I've done that many times when I've stepped out of session hall. I've always stopped the person and say, what is your name? Where are you from? What is this about? I will then turn to my aide and say, will you please take care of this? And I turn to the visitor and say, you may follow it up with her. That is normally what a politician does. We don't just accept pieces of paper. In my case, for example, because of threats to my life in a prior position and in a prior life, I'm careful to identify the person who is giving me something, especially if it is in the form of a package that I cannot visibly see from outside. So, we have to presume that things have happened according to the ordinary course of life. Lumalabas ka, sukat ka binigyan ng envelope, wala kang pakialam. Saka mo na lang binuksan, tapos, voila, there's an presumably illegally obtained document inside the envelope. Ngayon sasabihin mo, hindi ko intindi bakit narating sa akin yan. There's the law. The law says, Pag hindi mo pinapaliwanag yan, ang ibig sabihin, ikaw ang nagnakaw niyan. Kung pickpocket ka at nasa bus ka, pagkatapos may nawalang pitaka at ikaw may hawak, sasabihin ng pulis, ikaw palang magnanakaw eh. Anong paliwanag mo? Ngayon din yon sa ating kaso ngayon. That things have happened according to the ordinary course of nature and the ordinary habits of life. The other congressman said, I was driving into my house. In the driveway, I found attached to the gate or in a situation more or less similar, an envelope, and when I opened it, voila, there's the signature card. And there's no other further explanation. Is that an ordinary habit of life? To walk to your gate and find envelope stuck there? Don't you have a mailbox? Don't you have a house helper who can be trusted to receive mail in your absence? So I just raised these questions because, Ms. Witness, it appears to me that your behavior was exemplary. Thank you.
Thank you.
Thank you, Your Honor.